Thus far we have discussed 6 different types of offers. Today we will be dealing with the last 4 types of offer, starting from the 7th one called as definite offer. An offer to contract must be sufficiently definite, that is, the terms of the offer must be sufficiently specific to allow the offeree to understand and accept the offer. So, whenever one party is making an offer to another party, the conditions of the offer or the terms of the offer must be very much definite. That means it must be clear and it must not be ambiguous. Ambiguous means something that is hidden or confused, or there is no clarity in the terms and conditions. Example, I offered you my grandfather's antique watch for $200. You must tell me that you accept this offer in writing and I must receive it before 2 p.m. on Tuesday, or I will offer it to my brother. Look at this offer. Now the person is very specific about his terms and conditions, right? What is he selling? His grandfather's antique watch. What is the price of the watch? $200. And when does he want the acceptance to be conveyed to him? Before 2 p.m. of Tuesday, and that too in writing. So these are the specific conditions or specific terms and conditions laid down by the one party to another party. Understood what is a definite offer? There must be not any condition that is confusing or that is without any clarity or certainty, right? The offer must have definite terms and conditions. Next point, 8th, is standing offer. It is also known as open or continuing offer or a tender. Agreement under which a vendor allows a buyer to purchase specified goods or services at a predetermined price for a certain period on or as when requirement basis. Now, the standing offer usually happens with those companies or manufacturers who want to get some raw materials from their suppliers. Okay, so since the market price of certain goods or certain currencies etc. are always fluctuating, might increase or might decrease, correct? Therefore, it might end up in certain losses for the manufacturer. So what happens here is he is going to put across a standing offer. So the supplier is going to give a time period. So within that time period, at a predetermined price, see that last second line, predetermined price for a certain period. So let's say for 6 months, the price of the raw materials or goods, let's say we are talking about cotton here. So 1 kg of cotton is fixed for rupees 100. So at rupees 100 per kg, in that particular 6 months, the manufacturer can anytime, based on his production requirements, he can place a order with his supplier. Understood? So this is called as a standing offer. So within that period, the supplier allows or he is agreeing to sell those raw material, in our example it is cotton, to the manufacturer at a predetermined price for a certain period. Hope you have understood what is a standing offer. Next up, cross offer. When two people make identical offers to each other in ignorance of each other's offer. I am sure you have come across this cross offer in essentials of a valid offer. One of the last point that we discussed is an offer to be a valid offer, it must not be a cross offer. You remember that point in the essentials of valid offer when we discussed? So here we are going to learn what exactly is a cross offer. That is when two people, that is two parties to a contract, are making offers to each other in ignorance of each other's offer. Let's see the example. Mr. A wrote a letter on October 10th, 2010 offering to sell 100 kgs of ragi at rupees 100 per kg. Okay, A is writing a letter to B. On the same day, Mr. B is writing a letter to Mr. A to buy what? Same 1000 kgs of ragi, and his purchase price is also 100 rupees per kg. Now remember, A does not know that B is willing to buy, he is just giving an offer. B does not know that A is willing to sell and B is willing to purchase. Now therefore, A is ignorant of B's offer, B is ignorant of A's offer. Such an offer is called as cross offer. Okay, when these two letters crossed each other, both were unaware of each other's offer. Now remember, one of the major or the basic essential of a contract to be valid in the eyes of law is what? There has to be an offer and there has to be an acceptance. You got it? So if there is cross offer, who's going to accept then? Both the terms and conditions are same. So one has to offer and the other party has to accept. Got it? So this is termed as cross offer. The last types of offer is called as counter offer, just the opposite of cross. A counter offer is a rejection of original offer. Now there you are unaware of each other's offer. Here you are aware of the offer and you are rejecting the original offer. It is a new offer which needs acceptance by the original promiser before a contract is made. You understood? A counter offer is a rejection of original offer. For example, I offer to sell my laptop to you for rupees 50,000. You hear my offer, you are aware of my offer, and then you give me a counter offer saying, no, I would like to buy your laptop at 40,000 only and not 50,000. So this is called as counter offer. You are not agreeing to my terms and conditions. Instead, you are giving me a new offer which is called as a counter offer. Let's look at this interesting case. It's Hyde versus Wrench. The case of Hyde versus Wrench. Now here we can see the first picture. Who's Hyde and who's Wrench. Second picture we see that Wrench has a big acres of land and he is looking for a person to whom he can sell that land to because he wants that money for some other purpose. Got it? He has a big land. Third picture we can see that he has been looking for people who can match up to the price of that land. He is not able to or is not willing to come down to the selling price of the land at any point. He has fixed a price for the sale and he wants to stick to that price. He does not want to negotiate the price of the land. And then comes Mr. Hyde. Mr. Hyde is a businessman. He is looking forward to a large land, to a land where he can set up his new factory for the upcoming business or the extension of his business. So this is the facts of the case. Mr. Wrench is a landowner. Mr. Hyde is a businessman who wants to buy the land to extend his business. And then what happens? Mr. Wrench tells the price of the land is $1,000. And then Mr. Hyde tells Mr. Wrench, no, I would like to buy your land for rupees $950. What was the price Mr. Wrench offered? $1,000. What was the price, that is the counter offer given by Mr. Hyde? It is $950. And then what Mr. Wrench says is, no, I am selling it for $1,000 only. So he is not ready to negotiate even $1 less or more. He just wants to sell it at $1,000. And then the next picture says, Mr. Hyde, since he wants the land for his extension of business and he found that particular land suitable for his business opportunity, now he raises his standards from 950 was his original proposal. Now he comes back to Mr. Wrench proposal, that is $1,000. He says, all right, I don't want to negotiate. Whatever your price was, $1,000, I am ready to buy the land for that $1,000 only. For which Mr. Wrench tells, I am no more interested to sell this land to you. So Mr. Hyde is angry upon Mr. Wrench and he says that it was you who first gave me the offer of rupees or of dollars, $1,000. Now how can you refuse to sell the same land to me for $1,000? So he files a case against Mr. Wrench in the court of law. What was the fact of the case between Mr. Hyde and Mr. Wrench is that Mr. Hyde had rejected the original offer. Remember the meaning or definition of what is a counter offer? A counter offer is a rejection of original offer. Once Mr. Hyde agreed to buy at $950 in response to Mr. Wrench offer to sell at $1,000. It was a counter offer. Now let's see what does the judge has to say about Mr. and Mr. Hyde versus Mr. Wrench case. So the court says or the judge says there is no valid contract between the parties for the purchase of this land because there exists no obligation of any sort between the parties. So whenever there is a counter offer, it cannot be accepted in the court of law. On the original terms when the offer is made, you have to agree to it or accept to that terms and condition, then only the contract is legal and both the parties are obliged to perform the duties of the contract legally. If not, it is not performing to be a valid contract. Hence, counter offer cannot be termed as a valid offer.